Welcome back to Sunrise Daily. Today we're taking a look at some issues as it has to do with the judiciary, the fight against corruption, and then we'll delve into some other matters. But this morning we're joined by Chief Emeka Ngige, Senior Advocate of Nigeria. Thank you for coming on this morning.
Thank you, gentlemen.
Well, we've seen that prosecution has lost a string of cases, almost in quick succession, on the part of the federal government prosecuting some of these matters. This one, we'll start off with that of Justice Adeni Ademola. There was also part of that, his wife, Olabowale, and an SAN, Mr. Joe Aggie. So 18 criminal charges filed by the federal government against him. We see here the courts just struck all of them, and going through those cases one after the other, they couldn't prove anything. And many thought, this is a bit embarrassing. From your perspective, what do you think went on here?
Thank you. Well, I must start from the word go to say that I'm handicapped in making a full analysis of the decision of the FCT High Court. In the absence of the ruling, it has not been released to the best of my knowledge. I have not been opportune to read the ruling of His Lordship, OKKJ. But taking what we have read in the media, excerpts of his ruling, it appears that the judge relied on series of admissions made by the prosecution witness in the course of his cross-examination. So from what I have read, it appears that the prosecution witness, I don't know what happened, answered most of the questions to favor the accused persons. So those admissions may have led His Lordship in saying that there is no case for the accused person to answer. So that is the little I know from what I've read, that it was based on the admission extracted from that PW15, the DSS operative, who was admitting most of the question. You didn't do this, he said yes. You didn't do that, he said yes. May have influenced that ruling.
You know, but given the kind of attention that arrest by the DSS, because he was one of those who were arrested by the DSS in that operation, they say sting operation, you'd have thought that when they kept on releasing the information to the media, the arguments about the evidence they have stashed against them, you thought that by the time they get to court, diligent prosecution investigation would have been done, and then you appear only to find out that this seemed to just fall flat on their faces. Is this a question of investigation not being thorough?
You see, I will also refrain from making any conclusive remark.
But from what you've seen?
On the ruling of the FCT High Court, because apart from that, I've not seen the ruling. It is a court of first instance. His decision is appealable, and that decision can be overturned. So it is too early for anybody to now say the prosecution was incompetent or that they didn't do their homework well, because it's likely to be appealed against. And I have seen cases where the prosecution lost in this type of situation.
Upon appeal?
Yes, even on appeal, and the Supreme Court set it aside. The recent one being the case of Atuche. They lost at the Lagos High Court, lost at the Court of Appeal, only for the Supreme Court in December to overturn the decisions of the two lower courts and send the matter back for a trial. So nobody should make any conclusive remark that the prosecution didn't do its work, because it is a judgment or a decision of a court of first instance.
What perception does this case and other cases give to the a seeming dispensation of justice as against the fight against corruption. What kind of perception do you think that this has presented or has thrown up, especially on the face of the EFCC?
Well, the perception will not be positive for EFCC because, or not for, I won't say EFCC because this is not EFCC case. If you recall, it was DSS that carried out the operation, the so-called sting operation. It wasn't a sting operation. If you properly define what is a sting operation, it's not. But at a stage, I think EFCC took over the concluding part of that investigation, and thereafter, the Office of the Attorney General initiated the prosecution. So, the perception will be that they have not done their homework in rushing to charge. But you see, they're under pressure. The prosecution is under pressure because of the public interest generated by that raid. They were under pressure to immediately file charges, particularly from the revelation or from what has been disclosed in the media as what they found during the raid. So they were under pressure to charge the matter to court and then prosecute. And then it will interest you that for me as a prosecutor, I sense something when the defense, which is unusual in Nigeria, criminal matters, the defense applied for accelerated hearing. For me, that was a red flag.
They knew it was going to go their way.
I wouldn't say it's a red flag for an accused person to apply for accelerated hearing. It is very rare in Nigerian criminal trials. So for me, that is where the prosecution ought to look at their charges again and look at the preparation they have done. If you feel that there are areas that are still open for further investigation, you can withdraw.
In this case, when we look at this case and look at the case of the former First Lady, Patience Jonathan, also, who has had her accounts unfrozen. You've had the case of one of your learned colleagues, Ezokome, who has also had his accounts unfrozen. And all these cases have had to do with the Ant-Graft war. How much of an integrity, because we've also talked about integrity tests, we saw that with some other cases, how much of integrity has been eroded here?
You see, each case has to be determined on its own merit. First Lady's case, what happened there? It was not a trial. That EFCC obtained expertise in order to freeze her account. To freeze an account in Skybank and some other banks. Then First Lady was not joined because the account was not in her name. She brought an application to discharge that order because there are some of the companies or the accounts affected her. EFCC did not file a counter affidavit. So that is how the judge now said, in the absence of a counter affidavit, I hereby set aside my order. So for me, it could be a case of somebody not doing his job in EFCC in filing the appropriate counter affidavit to that motion. So for me, it's not a setback against war against corruption. They can do the right thing. It's not yet over.
Is this not demeaning, though?
It's not demeaning. You can have it happens every day in court just because it's high profile. There are cases that is called either the lawyer is not there or they didn't file the appropriate process. The court will proceed. The Ozekome's own, like I said, each case has to be determined on its own merit. What the judge held in that case, which for me is right, is that since another court in Ado-Ekiti, presided over by Justice Taiwo, has discharged or set aside the freezing order initially made in respect of that Chief Ozekome's account, that EFCC ought not to have come to him again in Lagos to make the same order. That is like foreign shopping. For me, he's right there. What EFCC should have done in respect of the Ozekome's money is to apply for injunction restraining him from taking that money pending the appeal, because they have appealed against the decision of Taiwo in Ado Ekiti. So once you have appealed, the court of trial or the court of appeal has jurisdiction to grant you an injunction pending appeal. And with that, Ozekome will not have taken the money away. Or there's no need for you to come to Lagos again to apply for a freezing order against his account. So, with greatest respect, the judge in Lagos High Court was right in his decision to unfreeze the account. So, for me, those three cases should not be used as an assessment that the war against corruption is failing, or that EFCC is failing, or that the government is failing. Three, you didn't mention the one they won before Justice Banjoko of FCT High Court. Somebody was jailed, or three persons were jailed there for the money that they made from the petroleum subsidies scandal, the money they made, and they didn't supply the fuel. They prosecuted it, and those people have been jailed. So I think it's a mixed grail. You win here, you lose here. But the appellate process is still there.